What is bid rigging in antitrust law? Have you ever wondered how some companies seem to win contracts without much competition? This could be due to a practice known as bid rigging. So, what exactly is bid rigging in antitrust law? Bid rigging is when competing companies secretly agree on who will win a bidding process. This collusion disrupts fair competition and can lead to inflated prices for consumers. Bid rigging can happen in many industries, especially where contracts are awarded through competitive bidding. Think about construction projects or government contracts. In these situations, companies might agree on who will submit the winning bid or how other bidders will act to ensure a specific outcome. In the United States, bid rigging is illegal under the Sherman Antitrust Act of 1890. This law makes bid rigging a felony, which means those involved can face fines, imprisonment, or both. Many other countries have similar laws, making bid rigging a recognized violation of antitrust laws worldwide. There are different ways bid rigging can occur. One common method is called cover bidding. In this scenario, competitors submit bids that are intentionally too high or contain unacceptable terms. This way, the designated winner appears to have the most competitive offer. Another method is bid suppression, where some companies agree not to submit bids at all, reducing competition. Complementary bidding is another tactic where bidders agree to share the contract by hiring each other as subcontractors if one of them wins. For law students, understanding bid rigging is vital when studying antitrust law. It helps illustrate how unfair practices can distort market outcomes and negatively affect consumers. For example, in government contracts, bid rigging can lead to taxpayers paying more for goods and services than they should. Bid rigging is classified as a per Southeast violation of antitrust laws. This means it is illegal regardless of the circumstances. If a bid rigging scheme is proven, it cannot be justified by claims that the prices were fair or that the agreement was necessary to avoid price cutting. If businesses or consumers are harmed by bid rigging, they can take legal action. They may file antitrust lawsuits seeking damages and injunctive relief. Under federal law and some state laws, they can even seek treble damages, which means they could recover 3 times the amount of the damages they suffered. Bid rigging is a serious violation of antitrust laws that can have major economic consequences. Understanding its forms and legal implications is essential for law students studying antitrust law. This knowledge prepares them to analyze and address such practices in both legal and business contexts.